Good morning and good afternoon. My name is Kathleen Regan, and I'd like to welcome you all to a LexisNexis complimentary webinar titled Starting Your Own Firm, Key Financial Considerations. Before introducing our speakers, I have a few announcements. For our phone participants only, if a problem arises during the program, please dial *0 for the operator. We will be using the hashtag LFWebinar to have a conversation on Twitter during today's program if you would care to join us. Please take note of the survey that is available to you. We ask that you please complete it as it provides excellent feedback for us so that we may continue to bring you outstanding programs that meet your needs. The panelists today welcome your questions. You can submit your questions via the Q&A section of the platform throughout our program. The panelists will try to address as many audience questions as possible. Please keep in mind all questions may not be answered due to time constraints. No questions will be asked verbally. And now I'd like to introduce our speakers. Matthew J. Costello, CPA, is a partner at Novak Costello CPA Group, LLC, a full-service accounting firm located in Chicago. Mr. Costello has over 15 years of experience in serving entrepreneurs and the small business community. Lisa M. Nyuli concentrates her practice in the areas of family law, including divorce, custody, paternity, adoption, civil unions, and representation of children as a guardian ad litem. On behalf of LexisNexis, we thank Matthew and Lisa for their time in preparing today's webinar. Lisa, the floor is yours.
Thanks, Kathleen, and good afternoon. This session will focus on considerations and decisions that you will find yourself faced with in starting your own firm, both financial and ethical, and Matthew and I will try to guide you in those considerations. My focus will be on the legalities and the ethical rules, and Matthew, as the CPA, will cover the financial decisions in greater depth. Because this is a national webinar, when I refer to any ethical rules, I am referring to the American Bar Association's Model Rules of Professional Conduct. Most states have either adopted these rules outright or have enacted ethical rules which are similar to the model rules. On the ABA website, there is a list of states that have adopted the model rules, which you can refer to if you have any questions. So our first slide is a participation slide. If you could please answer, have you started your own law office yet? We'll give you a couple seconds to respond. Okay, so it looks like the majority of you have either started over a year ago or are thinking about starting your own practice. So we'll try to focus in both of those areas as a way of kind of bringing everyone into the conversation. But to start with people who are thinking about it, one of your key initial questions is going to be, are you going to practice alone or with other people? As a sole practitioner, a space sharer, a small firm or partnership, you'll need to select the appropriate structure and entity for the firm. You may decide to become an associate in someone else's firm or a partner with another person. Your considerations should include your vision regarding the size and nature of your business, the level of control that you wish to have, the level of structure that you're willing to deal with, the business's vulnerability to lawsuits, tax implications, and that's where Matthew will help us, expected profit or loss of the business, and whether you need to reinvest earnings in the business. You also want to consider what kind of need you have to access cash out of the business for yourself. If you're selecting the right entity, and again, Matthew's going to help us with this, your basic choices are to either be a sole practitioner, and this is a person who is unincorporated. One individual owns the business. It's the simplest type of business organization and allows you as the owner maximum freedom to make business decisions. It does not exist legally apart from or distinct from the proprietor. Many people will use this type of ownership at the initial stages of operating a business, and the main thing to remember is that you individually are fully liable to creditors. Another type is a corporate ownership, and corporations are C Corps or S Corps. A C Corp is going to protect its shareholders from personal liability, since liability to the creditors is limited to the capital they invested, while an S Corp is generally for small businesses. Again, the shareholder liability is limited to the contributed capital, although you will find that creditors require personal guarantees from the shareholders. You can also be a partnership, which is a relationship between two or more individuals who join together officially to carry on the practice. Each partner contributes money or property, and each shares in the profit and losses of the business. In a partnership, each partner is jointly and severally liable for all businesses' debts. If one partner exposes the partnership to liability to third-party creditors, that partner can cause the loss of not only the partnership assets, but also the other partner's personal assets. Partnerships are governed and established from state law perspectives, and I believe most have the complex federal tax rules. There are also limited liability corporations, which are separate legal entities formed in accordance with organizational rules for the Secretary of State in your particular state. The owner assumes the risks of the business to the extent of only the assets inside of the business. Some states also provide for limited liability partnerships, and generally those are going to be limited to the partners practicing in certain types of professions like accounting, law, medicine, architecture, those types of things. And generally they're going to be used by those who are seeking more protection against liabilities that are arising from professional malpractice of the others who are practicing in the same entity. So those are our basic types of entities, and again, Matthew will go into greater detail with regard to tax implications. Next thing you need to decide is who you're going to be with as a practitioner. And if you, again, Rule 5.4 of the model rules is a rule that defines what your professional independence responsibilities are. And what these rules require is that you cannot share fees with non-lawyers except under certain circumstances, which are going to be identified within this rule. You shouldn't form a partnership with a non-lawyer if any of the activities of the partnership consist of the practice of law. If someone other than your client pays your fees, do not allow them to direct you or regulate your professional judgment. A lawyer shall not practice with or in the form of a professional corporation or an association authorized to practice law for a profit if any non-lawyer owns any interest, if a non-lawyer is a corporate director or officer, except that a non-lawyer can be the secretary of the corporation if that only entails performing ministerial duties, or if the non-lawyer has a right to direct or control the professional judgment of the attorney. running back for a moment and hitting on a couple of rules that also have importance in making your initial decisions. Rule 1.1 talks about competence, and while it may be sort of obvious that you need to be competent, you don't want to be a jack of all trades when you go out on your own. You need to know the law, have the necessary skills, be thorough and prepared, but don't represent someone in a matter that you don't know, that you should know, but you could also bring in another attorney to associate with you who's competent to provide that representation. Also look at Rule 7.1, which governs communication about what your skills or your services are. The rule states that a lawyer may not make false or misleading communications about the lawyer's services, and this includes misrepresentations of fact or law, communications that might create unjustified expectations, or compares one lawyer's services with another's, unless the comparison can be justified. Don't take on matters that you know or should know that you're not able to competently handle. So most of attorneys feel competent maybe when they come out of law school, but certainly within 2 to 3 years of practice. Some other attorneys might not feel competent even if they're 10 years into practice. And being competent in one area of the law may require you to have knowledge of multiple areas. For example, I practice family law. A competent family law attorney must also have knowledge of tax law, usually real estate law, debtor-creditor law, bankruptcy law, and with the aging public, elder law. You'll obviously want to look at your local area to see what is needed. You also have to ask yourself if you need additional education outside of CLE. Sometimes in order to provide necessary services to your clients, you will need to get additional areas of expertise, practice, classes, seminars, journals, and talk to other people who practice in those areas. The important thing for you when you're starting out on your own is to define the nature of your practice and know what you need to do to handle those matters. And these types of decisions will move you directly into advertising. As most of you know, traditionally lawyers found advertising to be distasteful. But obviously if you watch TV in the wee hours of the morning, you know that as the years have passed, advertising by lawyers has become more and more prevalent. Rule 7.2 governs advertising, and in addition to that, I would encourage you to look at your local state rules, since state by state there may be some nuances as to what's allowed and what's not allowed. Rule 7.3 deals with direct contact with your prospective clients. And this answers the questions, what can you do to go out and get business? And when you're starting your own practice, this is an important consideration for you. Any successful attorney will tell you that existing clients are your most important source of referrals. Other attorneys outside of your firm, judges, business people are also excellent referral sources. Now you can send out letters or advertising circulars provided that the materials and the envelopes are specifically labeled as advertising material. You can also solicit business under the auspices of public or charitable legal services organizations, social, civic, charitable, religious, other types of organizations whose purposes include but aren't limited to providing or recommended legal services. You may not, in any state, solicit a client who you reasonably know is in a physical or mental state that prohibits the client from exercising reasonable judgment in employing a lawyer. You also may not solicit a client that you know does not desire to receive communication, and you may not solicit a client who's represented by another attorney. Rule 7.4, communication of your fields of practice. You may specify or designate any area or field in which you or your firm concentrates or practices, but again, check your specific state because some states do not recognize certifications of specialties and expertise. You must be careful what words you use to describe what it is you do. And remember that separate rules apply for lawyers admitted to practice before the U.S. Patent and Trademark Office or who are engaged in admiralty law. So what do you need to do to open the doors? Well, you need to have at least 2 bank accounts. One would be your operating account, and another would be your trust account. Into your operating account, you're going to put your earned fees, other income, and you're going to pay your operating expenses for the firm. Payroll, rent, those types of expenses. You should not be paying your personal bills from this account. In your trust account, and you should have a trust account, the first consideration is what type of account it is. Is it going to be an IOLTA account or just an escrow, a client escrow account? I believe that most, if not all, states have IOLTA accounts, and that stands for Interest on Lawyers Trust Accounts. And in those, the net interest on the account does not go to the client or the attorney, but instead goes to an entity within your state, usually the lawyer's trust fund, which funds legal assistant programs throughout the state. The rules provide that nominal or short-term funds of the clients or third persons must be deposited into an IOLTA trust account if your state has one. Large amounts that are being held for a long period of time should be placed in an interest-bearing escrow account solely for that client. So one thing to consider is your relationship with a bank if you're going to be doing a type of law, personal injury, real estate, other areas that would just require deposits that are going to be held. You may need to have 3, 4, 5, 10 client trust accounts that are interest-bearing for these types of money. The decision where you're going to put the money is solely in your discretion as an attorney. However, you do need to remember that the professional rules require you to do certain things and not to commingle funds, client funds, with your own. Your trust account must be in the same state where your practice is located, and just as a practice tip, when you're picking out your physical checks, make them a different color so that you don't accidentally write checks that belong to a client from your business account and vice versa. Most of the trouble that attorneys can get into is related to commingling or not having sufficient funds to cover clients' money. Talking about expenses that might be advanced, if your client pays you money for litigation costs and expenses that are going to be incurred in the future, you must deposit those into a trust account until they're available or until they're going to be used. Settlement checks. Typically, these checks will come in payable to the client, the lawyer, or the firm, and possibly other third parties, sometimes a medical provider and a personal injury. First, you have to secure all the necessary signatures and then deposit the check into your trust account and wait until the funds are determined by your bank to be available for withdrawal. You cannot deposit these types of funds into your operating account, even though it may be tempting to do that, but it's violation of the rule, and you have to segregate these funds by putting them into the trust account. And then make sure that funds are available. People know that funds are more easily available these days, but we always, as a best practice, contact the bank to make sure they have received the monies and it's available for distribution. Sometimes you'll find with larger amounts that the banks hold on to them longer. If you're handling real estate closings and acting as a closing agent, you should use a separately segregated account that you established prior to the closing and maintain solely for receiving funds in and then dispersing the funds out. If there's a dispute over the amount of money that's in a trust, you are required to maintain the disputed amount in the trust account until the dispute is resolved. And sometimes that may require you to go to court or to file a petition with the court to either deposit the funds or for resolution of the dispute. Bank charges and fees is also an issue with regard to trust accounts, because what the rule provides is that you can keep enough in to pay nominal bank charges, but in your trust account you're not to keep any more of your own money other than what's necessary to pay those charges. You must maintain records, written records of any deposits of your own funds that are in those accounts, so that if your account is audited, you can provide proof that you are not commingling beyond nominal bank fees. So Rule 1.15, and I've provided the text of the entire model rule here, but just to point out a couple aspects of it. The funds do have to be kept in a separate account in the state where the lawyer's office is situated. You may deposit your own funds for the sole purpose of paying bank service charges, but only in an amount necessary for that purpose. And into a client trust account, you are to deposit all legal fees and expenses that are paid in advance, and they can be withdrawn only as the fees are earned or expenses are incurred. If you receive a claim against this account, you have to contact your client promptly, and you have to promptly account for any funds that are in a client trust account. Now, one of the issues that comes up and has kind of been generating some articles and some ethics opinions in various states is related to accepting credit card payments. And this is certainly a consideration that you're going to have when you start your own firm. Allowing a client to pay fees by a credit card is a convenience that every firm should consider. It's convenient for the client. You can have your clients authorize regular monthly payments. A lot of times it'll speed up payments, and it may avoid payments being made in smaller installments. Also, it allows the credit card company to be the finance person or entity for the client rather than you. The detriments to accepting credit cards is there is a cost to your firm, costs of processing, and you should shop around to obtain the best possible processing rates that you can get. You also need to have a signed engagement letter, and you should at some level have a signed communication from your client authorizing you to use that credit card. But the biggest problem comes in with the potential commingling. Are you going to allow your clients to pay retainers by credit card? Since you can't commingle your funds with your client's funds, the client trust account can only have enough money to, as I said, cover your nominal expenses. The problem is that credit card expenses fluctuate. So it would be hard for you to deposit sufficient funds representing each retainer payment to cover the percentage that you need for each deposit. So you might ask, well, if we accept credit cards, why don't we just have the credit card funds deposited into our general operating account and then immediately move it out into the trust account? And that's certainly a solution, but some state bars have taken the position that by doing that, depositing a retainer into your operating account, even if you immediately take it out, you have commingled the funds. The best practice is to have two accounts for credit card payments. One, you can use your operating account for regular earned fees that clients may pay as the case goes on, and then a separate account for retainers, so that credit card retainers only go into the one account, and you can then estimate how much additional money you need to cover the fees. You should also have malpractice insurance. I think that when many people start their practice, they make the mistake of assuming they won't need malpractice insurance. But in addition to actually making mistakes, malpractice claims come from a whole variety of places, including and whether they're earned or not earned, missing deadlines, being unresponsive, potential conflicts of interest, fee disputes, and the commingling of funds. We also need to talk a little bit about Rule 1.5, which covers fees and retainers. So there's two types of retainers that I'm certain everyone is familiar with. The classic retainer, which is when a client pays you in order to secure your availability during a specific time or for a specific matter. It's earned when it's paid, and it's immediately property of you. So you can deposit it into your operating account and use it. Then there's a security retainer. The security retainer is funds that are paid to you, but they're not considered present payments for future services. They're intended to secure the payment of fees for future services that you're being expected to perform. These types of retainers should remain the property of the client and must be deposited into a trust account and kept separate from the lawyer's own property until the lawyer applies it to the charges for services that are actually being rendered. Unused portions are being refunded to the client. In Illinois, we also have an advanced payment retainer, which has turned into a complex concept and was originally defined in the case of Brian Dowling versus Chicago Options Associate. And let me give you the cite on it. I don't see that it's coming up on the slide. It's 226 Ill 2nd 277. It's a 2007 case. And the advanced retainer is defined on this slide. But as I said, this is something that I think is specific only to Illinois. And if you have it in your state, you can take a look at this case, and it pretty accurately provides guidance to determine what type of retainers are applicable. Moving on to fees and costs, you do have to set your fees when you go out on your own. And remember the types of billing complaints that people have. Make sure to disclose your fees. Your clients must consent to the fees. You should always explain them at the beginning of the representation. I've provided some different guidance in the outline for the different types of fees that there are. Hourly, which lawyers love and clients hate. Task-based billing, which clients also love and lawyers probably don't like as much. And then flat fees, and there's certain types of cases where flat fees are more appropriate than other types. There's also contingent fees for certain types of cases, and if you're going to charge a contingent fee, you need to take a look at Rule 1.5C and D to make sure you have the type of case that can be subject to a contingent fee. Generally, as I indicated before, Rule 1.5 governs fee splitting as well. Generally, you are not to divide a fee with another lawyer other than a lawyer in your same firm unless the client consents to the employment of the other lawyer and signs a disclosure stating that the division of fees will be made, the basis for the division, and the responsibility of the other attorney for performing services. And I'm going to jump to the end of this presentation, and I got there, I see. I did provide a handout that has a sample law office budget. And this is something that was given to me when I was a sole practitioner, and it's pretty helpful in trying to figure out how much money you're going to end up with as a practitioner. My basic question is, obviously, at the end, what's left after I pay all these bills to pay myself? Income minus expenses equals my money. But there's many, many considerations and expenses that lawyers need to consider in terms of how they're going to set up their practice, what should be necessary, what isn't necessary, and how do we get to that bottom line. One of the benefits to starting from scratch is that you can start a practice at a bare bones and then add something as it's needed. When you join together, certain partners or people that you practice with may decide certain things are necessary that you don't think are necessary, and vice versa. The budget that I've presented here has actually been the accumulation of a lot of the expenses that my firm has developed over the course of many years. And there are a lot of items in here, but you can see where overhead could get out of control. And one of the things that's so available to you, like the seminar, which is for free, is there are many, many resources out there that provide free or limited cost services. So consider Bar Association memberships, because while you pay a membership fee, many of those bar associations will include things like free legal research, free CLE, free mentoring. And the more of those types of items you can have for free, the more money goes into your pocket at the end of the day. And I can see that I've run past my 30 minutes, so at this point I will turn this over to Matthew. If you have any questions, we'll certainly be taking them at the end.
Hello, everybody. This is Matthew Costello. Thank you for being here. And Lisa, thank you for your portion of the webinar. I see that there's a lot of things that attorneys have to consider. That's even before we get into the accounting and tax considerations. While it's still fresh, Lisa was just talking about the budget and the importance of generating a budget for your firm. It's very important. But one thing that I want to stress is just because you create a budget, that does not mean you're done. Creating a budget is the first part of it, but the most important part then is the follow-up on the budget. Follow up by comparing actual results to your budget, and then that will identify items where either you budgeted wrong or items where your budget probably was, right on the money, but for some reason they got out of control, and that's something that you can change. So yes, budgets are very important, and then it's also very important to follow up and treat the budget as a working document, something that you look at every month, every quarter, every year, how often you think is necessary, and then taking the actions to correct the things that need to be corrected. Okay, so first slide. Well, the first thing I want to say is I saw the poll question. The poll question was, when did you start your firm? Are you thinking about starting a firm? It looked like it was, maybe 50-50 or so with people who have already started a firm within the last year or so, and then people who just started and who are thinking of starting. So good, we got a little bit of a mix, and the items that I'm going to talk about, they apply to everyone. For those of you who are already in business and already have been practicing, maybe some of these things will hit home and you're like, oh yeah, I just experienced that. And for those of you who have yet to start or are thinking of starting, these are things that I think you should consider. For those of you who haven't started off yet, you're going to see that there's many challenges when you're starting your own firm, because now ultimately you are responsible for every aspect of the operations of the firm. If you're coming from an environment where you were an employee of a firm or a partner in a firm, you had a much greater level of support, at the partner level, and also administrative and also professional level, where a lot of things just seem to be taken care of. You didn't have to worry about them. Well, that's all going to change when you decide to go out and start up your own solo practice. Now, ultimately, you are the one responsible for all aspects of operations, administration, human resources, technology, and, oh yeah, that's right, you guys have clients too. You got to worry about all the client matters too. So, it's a large burden. It's it's something that you're going to have to do, and ultimately you're responsible. And when you look at the resources you have to meet all these challenges, you know, it's your time. If you have employees, it's their time, and it's your capital. So these resources look like they might be scarce compared to all the challenges you have. But you know, there's ways that you can go to try to mitigate this burden. Some fantastic sources that you can use are, if you know someone in your network that is an existing solo operator or an existing small firm, they are going to be a fantastic resource for you. These are people that have, you know, just have gone down this path before you and have made, I'm sure, many mistakes, and I'm sure have done many things that were good. They are a great source of knowledge to help you as you try to navigate, you know, how to, you know, take on this task. As Lisa pointed out, your state bar or the ABA or various industry groups, great source of knowledge. There's a lot of information there, and you know, it's you know, I'm sure there's resources there where, you know, in addition to seminars like this, they probably have resources there where they can help you, you know, go down this path. And you know, in the danger of making this sound like a public service announcement for the CPA community, but CPAs are a great source too. If you don't have an existing relationship with a CPA, if you're thinking about starting your own firm, I highly recommend that you, you know, reach out, try to find a CPA that you're comfortable with, because they can help you, you know, navigate a lot of the things I'm going to be getting into later. Okay. So all these challenges, all these things to do, less resources available to meet these challenges. What can you do about it? Well, the items on this slide I like to think of are just as the important concepts, you know, the key things that are going to take many shapes and forms when you actually do them. But these are the main concepts that I want to stress, is that to whatever extent possible, you should try to outsource all non-revenue producing activities. You know, that's whatever administrative tasks, whatever accounting and finance functions that you can outsource, try to do it to the full extent possible. You know, the way I look at it, and the way when I talk to, you know, my clients who are attorneys, or anyone who really bills by the hour, is, you know, every hour that is spent on accounting or admin or any other non-revenue generating tasks is one less hour of revenue generating task. You know, it's a linear equation. You know, if you're spending 20 hours a month on accounting, you're not spending, that's 20 hours less you're spent on billing. You know, always think about trying to put yourself to your highest, best use, and that's usually going to be billing your clients, rendering the services. You should take every opportunity you can to either push down or push over tasks that do not generate revenue. To whatever extent possible, you should try to automate processes and document processes. And what I mean by that is, I don't know, it's pretty much anything that happens. You know, it can go down to just the monthly list of things you got to buy for the office. Put down a checklist, automate it, put some system in place where you don't have to think about that every month when you have to reorder coffee. You have to, you know, reorder paper or something. To the extent that you can automate processes, it's going to, in the long run, it's going to lead to more time for you to bill your clients. You know, it is a good day and age to be a solo practitioner, and that is mainly due to the way the advances in technology over the past 5 years, 5 years, is just, it's incredible. Currently, my firm, I work in a small firm. I'm not practicing law, but I'm practicing accounting. I'm in the professional services industry, and I can't tell you how much technology has improved over the past 5 years, where I can do things now that it would take me either more time or more bodies to do 5 years ago. This technology is out there, and it's there for you to use and for you to leverage it. We're going to get into just some of the accounting technology a little bit later. Another thing that you got to do is you have to take a proactive approach to planning and forecasting the financial health of the firm. It's now that you're on your own, and you can't just put your head down and just work on client matters and not worry about the administrative tasks. Now you're responsible for everything. You have to be involved in the financial health of the firm. That doesn't mean that you're spending a part of your day every day, logging in accounting entries. What it means, though, is that you still have to be, in touch and on top of your receivables, your billings for the month, your payables. You got to know what bills you have to pay. You have to know who owes you money. You have to be on top of all these things in order for your firm to, to perform at its highest level. Accounting considerations. Okay, the first question, do I really need an accounting system? That answer is yes. That's it. No spreadsheets, no Word documents, no pile of receipts in a shoebox that you're going to account for later. That's not going to cut it. If you're starting off your own firm, you're a business, you should act like a business. Number one, there's IRS guidelines, that you should keep, adequate books and records. Yes, that's one part of it. But the other part is there is no way that you're going to be able to gauge the financial health of your firm and be able to, make informed business decisions if you don't have good financial information. So yes, you're going to need an accounting system. Then I would say that the next decision in the decision tree is, you hear a lot about this cloud accounting, cloud-based programs, accounting being one of them, or an on-premise solution. So a lot of the developments that I've been talking about over the past 5 years it's in the cloud accounting space, where nowadays when I look at people starting up a business, that's my first recommendation is I say you take a good look at cloud-based systems. They do have many benefits. The main benefit is the ability to access your accounting data from anywhere. You don't have to be in the office to get at your accounting system. You can be at home, you can be on the road, you can get it from any device, pretty much from anywhere that has an internet connection. I think that's a real valuable benefit. Another benefit it has is not only do you have access to it from anywhere, is others do also. Now others could be your employees, it can be your third-party service providers, or anyone who works in your firm. It could be contractors. Anyone who you want access, who you want to have access to it, can have it. So if you have some contract attorney working for you and you need him to enter his time, he doesn't have to mail in email you a timesheet for someone in your firm to enter into your system. He can just go jump right on and enter in his time and billing. What it does is it cuts the tether. It cuts the tether from you and your team away from the office, where you're not required to be in the office to get work done. You can do it from anywhere. It works with for human resources. If you have employees who want a little bit of flexibility, where maybe you can have an arrangement where they, can work at home from one day, or however you decide. and they can still be productive. They still have access to what they need, and they're doing it remotely. But there is security issues. You know, there is the one question that you just have to address, you know, before you even think about going to a cloud-based solution, and that's the security issue. And it is a valid concern. The way that I usually explain it to people is I ask people if they have any concerns with logging on, going through the internet and logging on to their bank information and transacting at their bank. Usually the answer is no. You know, online banking is you know, pretty common. I'd say the vast majority of people do it. If they don't have a problem with doing that, I tell them that when you use a reputable cloud-based vendor, they're using substantially identical sort of security on with their program. So in my mind, I think the security issue is not that great. You know, but do know that, you know, it is out there. Another consideration is the backing up of your data. On a cloud-based system, you have a much better backup system than you would on your own premises. You know, once again, with a reputable cloud-based vendor, they back the data up. You know, they send it in. You know, it's probably mirrored back up in 2 different data warehouses in two different time zones. I do feel rather secure about the backup of my data. Okay. So you know you need an accounting system, and you know you're either going to go cloud-based, or your choices are either in the cloud or on-premise. What are some good options of an accounting system? Well, there's lots of them out there, and this list is just a couple that I'm familiar with, and then I can say that you know, would be a good bet. QuickBooks, I'm sure most of you have at least heard of QuickBooks, and it really is, as far as the small business market, it completely dominates. It has probably greater than 90% market share for the small business accounting. It's a great product. It's been around forever. One of the benefits that QuickBooks has over others is that the user community is extremely large. If you need help in training or support, or you want to hire a bookkeeper or someone to help you with your books, you will have no problem finding someone who knows QuickBooks and is familiar with QuickBooks. One name that I do want to mention is Xero. It's a relatively newcomer. You know, I think they've been in the U.S. for, say, 2-3 years. They're a New Zealand-based company, and Xero is a very, very impressive accounting system. It does a lot of things. It's pretty powerful. You know, I would say if you're going to make the choice and go with a cloud-based system, you should really give Xero, I think, a pretty good look. Another one of the main vendors in the space, traditional vendor, has been Sage. They've been around for a long time. They have both on-premise and cloud-based solutions. They're a good outfit. They've been around for a while. So those are really the big 3. There certainly are others. There's, you know, let's say, you know, if you look hard enough, you can find dozens and dozens of different accounting packages to choose from. I would say, though, as a consideration is if you're using a practice management system, one of the things you want to consider is, does your choice of accounting, does your accounting package integrate with your practice management system, or even your time and billing system? If you're using a separate time and billing system, look for an accounting system that integrates, that has pretty strong integration features, because that's where you're going to find, you're going to gain efficiencies. You know, the more your programs, different programs talk to each other, the more efficient you're going to be. Okay, you need an accounting system. You've chosen either cloud-based or on-premise, and you've chosen a specific product. Now, who's going to do the actual accounting? Ideally, you will do as little as possible. Goes back to what I was saying earlier, is every time spent on accounting is one less time that you can bill your clients. You know, that's one of the main things that I want to stress. But okay, let's say you believe in that. That doesn't absolve you from any accounting duties. Even though you're not going to be the one, you shouldn't be the one pushing the paper. You still have to be in tune with the financial health of the company. And what that means is you have to be in tune with who owes you money, how much money you owe other people, what your cash balances are, and are you hitting your targeted billings? Those are the main things that you do have to be on top of, no matter who does the accounting. So ideally, you do as little as possible. That's something that administrative staff can handle with your oversight, of course. You can always outsource it, and that's what I said earlier. When you outsource something, you free up internal time, and you're outsourcing that function to someone who does it for a living. Most likely, you're going to get a higher quality product, in a more timely manner. Outsourcing is always something to look at. Robots, oh my gosh. Robots. With this new technology, they have these accounting packages that I was describing earlier. They have where they go hook up to your bank accounts, hook up to your credit card accounts, and automatically go and grab all the transactions and pull them into your accounting records, and they're there already. So it alleviates a lot of the data entry that's necessary. So this is going to be a big time saver for whoever is performing your accounting. All right, I'm going to start moving a little bit quicker here because I know we're getting low on time, because we want to allow for some time for questions later on. So the key to streamlining the whole accounting and finance function is to setting up the right processes and utilizing the best tools. Things that you're going to want to look at when you're deciding on accounting packages, it must be able to accept direct bank and credit card feeds. That's what I spoke about. So you're looking to perform as little data entry as possible, where you have real-time financial information. You come in the morning, you turn on your machine, you open up your accounting file, and bam, right there on your dashboard, you're looking at, this is how much money I have in the bank, this is how much people owe me, this is what I owe, and you have that anywhere. Look for integration with other of your key programs that you use in your practice, such as your practice management system, your time and billing system, and maybe a CRM, solution if you use one. One thing that is just in the CPA space, in the accounting firm space, is over the past 10, 15 years or so, there's been a huge move towards paperless, and I tell you, I cannot even think about going back to the days of before paper. I know there's been some, major strides made in the attorney space also. If you're not paperless, you should really think about at least taking the steps towards getting somewhat paperless. If you are paperless, good job, keep it up. Try to become even more paperless. So no matter what system you use, who performs the work, or whatever the deal is, these are the things you should really pay attention to. You have to stay on top of your receivables. You should review them frequently. Review your receivables report frequently, and follow up with any receivable that's getting owed. Monthly, you should reconcile all your cash accounts, and from what Lisa was saying, all possibly 3 minimally of your cash accounts, and any credit card balance, any credit card account that you have to reconcile these things monthly. Your WIP, billing, and receivables should be analyzed frequently. You know, this targets people that are slow paying. You know, why would you go ahead and, you know, rack up another 20 hours on time if this client hasn't paid you for, you know, for the past 2 months? That's something that you got to be on top of. Back to the budget. It's good you make a budget. You got to then compare what your actual results to the budget and then make changes as necessary. It's going to point out some weaknesses. It's going to point out, you know, areas where you can improve. You know, make it easy on yourself and your accountant, but on yourself, and try not to commingle business activity with your personal finances. You really should have a separate, well, you have to have separate cash accounts for the business. You really should have a separate credit card for the business. You know, have one for your personal life, or 5, whatever you want, but have one that's dedicated solely to business. It just makes your accounting and record keeping that much easier.
Matthew, I'm going to interrupt you. I apologize. With only about 4 minutes left, I'm going to ask you and Lisa could take a moment and perhaps answer maybe 2 or 3 questions for our audience. And for our audience members, you have the opportunity to download the complete PowerPoint deck in the handouts widget, which is in the bottom center of your console. It's the piece of paper with the folded corner icon. That's where you can find your PowerPoint deck and also the model budget that Lisa prepared for you. So again, Matthew, I apologize for cutting you short, but there are some really good questions that I would ask you and Lisa to take a moment and see if you can get through a couple in the next 4 minutes.
Sure. Okay.
Sure.
And I want to say the apology is all mine. You know, I didn't do my timing right. I left out a whole bunch of stuff. So I want to say to all the participants, please, if you have any questions, so I know I didn't get to the income tax issues part of this. Please feel free to send me an email. My email address is on the slides, and I'll try to get to whatever questions you have. Okay.
Just starting out, Matthew, a comment was made from the audience. That's a good comment, and I apologize if I passed over it, indicating that a corporation does not shelter an attorney from liability from their own malpractice. The corporate formation only shelters from third-party creditors and malpractice of other attorneys and shareholders in the firm.
Yeah, I think you're right. You can run, but you can't hide. You know,
exactly.
If it's due to personal malpractice, no matter what form you're operating out of, you're liable, I believe. But I'm not an attorney. Maybe I'm
right. Then we also have a question. It's a 2-part question. I'm going to address the second part first. Can the processing fees on a credit card be passed on to the client because it's a convenience for the client to pay by credit card? And like every lawyer should be familiar with, the answer is going to be it depends. And I know in Illinois there's an ethics opinion that says you can pass it on to the client as long as you've disclosed it in advance and it's a reasonable amount. I also know that there's an ethics opinion from another state that says you absolutely cannot pass it on. So check your own state and follow accordingly. But that's a really good question, and it's something that I think when you're looking at the convenience and the cost of these things, it is something that you have to consider. We had a question about discussing the of counsel designation, and that's a really good question as well, because I think a lot of practitioners now are solos and small firms are teaming up with other lawyers, designating them as of counsel in specific practice areas to give the feel of a firm that maybe is able to handle all different types of law without having to actually have those people as employees. And the things to remember, most model rules do cover this, either in opinions or the actual rule, but the person who is of counsel to the firm isn't an employee of the firm, cannot be an associate of the firm, cannot be a partner of the firm. They do have to have a designation, and they do have to be affiliated in some fashion. You can't have conflicts of interest, and they have to be designated on both letterheads. So there are some challenges with that, and even more importantly, you're going to want to talk to your malpractice provider and make sure to comply with their rules regarding how they handle of-counsel relationships. Typically, you cannot have someone of counsel who, if you have malpractice insurance, who doesn't also have malpractice insurance. And why would you want to do that anyway?
Yeah.
And with that, I am going to have to wrap up today's webinar in the interest of everyone's schedule. On behalf of LexisNexis, I'd like to thank Matthew and Lisa for today's program. Please feel free to contact them directly if you have questions you'd like to explore further or things that you wanted to address that we just simply did not have time to do today. Matthew also has additional resources that you may find useful. He can be contacted via email if you would like to receive those links. And as a reminder, Lisa's model budget is available in the handout section. Today's attendees will also receive an email with the webinar recording. And as a reminder, this webinar is the first in a three-part series on starting your own firm. Please look for additional information about the series in an upcoming email. If you'd like to stay in touch and get helpful legal news and resources, please follow us on our Twitter feed at LexisSmallLaw. Thank you all and have a great day.